Welcome to Looking at Legal Stuff. Today we have an evidentiary hearing in the case of a pro se couple where dad is trying to get full custody of his children after he claims his ex refused to let him see them. He says she cheated on him and left with the children to live with her unstable and violent new boyfriend. He claims she refused to allow him to see the children anymore after an incident with the boyfriend and their son that involved dad calling the police. Mom claims that she's let dad see the children lots of times, and he's the one who wouldn't bother to show up. She says she only decided that he didn't need to see them after he called the police and CPS on her. What does the judge think of this and all their other accusations? Let's find out.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Thursday, July 13th, 2023 at 8:27 a.m. And this is case 2022-3116 DC, Fawn March versus Earl Roberts IV.
Okay. Good morning to both of you. Before we commence, I just want to give you a little bit of instruction for the way we're going to proceed and let you know that this is a court proceeding and you must conduct yourself as if you were personally in court. You are appearing virtually, but it looks like both of you have found a place where you have good internet connection. So I'll ask that you stay there, don't wander around. And if you should get up at any point and take off, don't drive around either. I've had people that have been in a home and then they get up and decide they're driving someplace. Don't do that. I'll let you know that everyone will have multiple opportunities to speak. So don't interrupt each other, any of the witnesses. And except should you have a valid legal objection, which you can make at the time that it arises. And I'll say, do not interrupt me as well. Do not make comments while someone else is speaking or testifying. You'll be given, again, an opportunity to respond to anything that anybody says. If you engage in offensive conduct or interrupt the court proceedings, you could be held in contempt of court and you could end up going to jail. Court proceedings, I'll tell you, are often emotional. And if this happens, take a moment and compose yourself. If you need more time, you can ask the court for a brief recess. Well, you have an opportunity to calm down. You are not attorneys, however, because you have chosen to represent yourself, you'll be held to the same standard as if you were an attorney, meaning that you have to handle the matter and you have to address all of the legal issues that you would normally address in one of these proceedings. Ms. March, you are the plaintiff, so you'll be given an opportunity first. Let me ask you, Ms. March, do you have anything preliminarily before we start the proceedings?
No.
Okay. Mr. Roberts, is there anything you have as a preliminary matter before we commence?
No.
Okay, thank you. Ms. March, you have an opportunity to make an opening statement if you'd like to do so. So if you would like to, you can make an opening statement now.
The only thing I have to say is I've had the kids full time and I really don't know what to say. I take care of them full time. I bathe them, I feed them, I keep them financially stable. That's really all I have to say right now.
Okay, well, you'll have more chance when you give testimony to do that. I just usually in an opening statement, people will outline their case and then they'll highlight anything maybe that they're going to say or witnesses or anything of that nature, but you're not required to make an opening statement.
Okay.
Okay. Mr. Roberts, do you wish to make an opening statement, or you can waive your opening statement, or you can reserve your opening statement?
I'd like to make an opening statement. I'm really just trying to make sure I can see my kids and everything like that. That's the whole thing. I want to fight for. I've just had all contact been absolutely cut off, and that's about it. You know, all I'm trying to prove is that I'm ready and willing to see and take care of my kids.
Okay. When you say see them, is just to clarify, because we're going to go through a custody proceeding. When you say you want to see them, does that mean that you want parenting time? Is that what you're looking at?
Yes, I would like yes, I want parenting time.
Okay, so you're not, at this point, you're not seeking custody, just simply parenting time.
Oh, no, that's my bad. No, I would like custody. Absolutely.
Okay.
That was my misunderstanding. I apologize.
Okay, that's fine. Well, why don't we proceed then, Ms. Marsh? This is your opportunity to present your case, any witnesses that you might have. So,
I don't have any witnesses.
okay. Well, do you want to testify yourself?
Yes.
Okay. Then what we'll do is we'll have you sworn in, and so if you would raise your right hand, we'll have you sworn, and then we'll take some testimony.
Okay.
Ma'am, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Go ahead, ma'am. What would you, I'll let you have an opportunity to tell me what you'd like me to be aware of, and then I'll ask you some questions as well, and the defendant would have an opportunity to question you.
Okay. Well, he says that I haven't been letting him see the kids. That's not true. I have let him see the kids plenty of times. But just recently he has called the cops and made false accusations. And he's also called CPS and made false claims to CPS. And I just didn't feel like he needed to see them after that, because he
Okay.
so yeah, like
Okay. Might be easier, again, I can ask you some questions. In this particular matter, you had filed the complaint on or about November 21st, 2022.
yes.
Tell me, at the time that you filed the complaint, where were the children at? Whose care were they in? How long had they been in the care? And what kind of things did you do with them at that time?
They've been in my care, and I've had them like this whole time.
Well,
Like,
okay, you have to tell me what whole time is, because people will use generalities and that doesn't mean anything to the court. So whole time could be 2 weeks, it could be 2 years. I don't know.
They've been with me since November until now.
And say from November to now, let me,
Yes, I mean, I'm sorry. They've been with me since like they've been born. I'm
Okay.
sorry.
Okay.
Sorry.
Well, see, that's a little different. So that's why.
Yeah, sorry.
And when did the two of you and the defendant, when did you separate?
We separated in November.
Okay. And tell me what happened when you separated. Did he move out? Did you move out? Did both of you move out? I don't know.
I moved out.
Okay. And just so you know, as I ask the questions, that's why I'm asking, so you understand. The court has very little information about the case. So that's what I'm trying to do, is garner as much information as I can to, again, make a determination based upon the best interest of the child test that can basically encompasses 12 separate factors that I have to look at. So again, you can't talk in generalities. You have to tell me what happened, when did it happen, how did it happen, and specifically what occurred. So you moved out in November sometime,
Yes.
correct? What did you do when you moved out? Where did you move to?
I was living, I went to go live with his stepdad.
Okay. And how long did you stay there?
I stayed there for a short time, like about 3 weeks.
Okay. And what did you do after the 3 weeks?
I was working.
Okay. That, again, that doesn't tell me anything. When I'm asking you where you stayed and you say you were working, did you stay at work then?
No, oh my God. No, I was staying at my mom's after that.
Okay. And how long did you stay with your mom?
I've been with my mom, after that until now.
Okay, so you're currently with your mom.
Yeah.
Okay. And explain to me, if you would, what the home is, what the home's like, the configuration, rooms, things of that nature.
It's like a farmhouse, like a small farmhouse. It's got 3 bedrooms.
Okay. No other rooms in the house other than
No,
3 bedrooms?
it's got uh like a decent sized living room and dining room and a kitchen. It's 1 bathroom.
Okay. And what is the configuration as far as the living arrangements with the kids? Do they have their own room? Do they sleep in the same room? Do they sleep in rooms with someone else? What?
Like my daughter sleeps in a room with me and he has his own room.
Okay. Okay. Do you have any plans to move, or are you going to be staying there for the new, for the foreseeable future? What?
In the future, I'm planning on moving. I'm trying to save money to move.
But no current plans at this point other than future plans.
Yeah.
Okay. Since from the time that you did separate in November to the current time, would you explain to me how often has the defendant had the children in his care?
Like he's probably seen him like 3 times. And I know he saw them in a couple times in April and like for like a day, and then Another time, I can't remember the exact day, but he did see him another time, like before that, but he only had him for like a day.
So based on what you said, approximately the 3 times you've seen them, he's had them for a day. Now, again, only because it's important, a day is 24 hours. Did he have them the entire day of 24 hours? Did he have them for 9 hours?
No, for 24 hours.
What?
For 24 hours.
Okay. So from November to the current time, he basically has had them for a 24-hour period, approximately 3 days.
Yes.
Okay. Has during that time from November to the current time, had he requested other times where he didn't get the children?
He did want to take he was gonna go see his son Earl Wayne Roberts V. He said he was gonna go see him, and then I went to go pick him up from the babysitter, and he was freaking out because he saw me and his dad wasn't there, and he kept yelling at me saying, "My dad's supposed to come see me," and dad just didn't come.
Okay, so he had made arrangements with you to pick up your son from daycare?
Yeah, from the babysitter, yeah.
Okay, well. If in fact if he made arrangements to pick him up from the babysitter, how did you know that he wasn't going to arrive and pick up the kids?
I didn't know well, he didn't I'm sorry, he didn't tell me. He had told the babysitter he was gonna come see him, like visit with him,
Okay, so not pick him up.
not pick him up. He was gonna come see him, and then he didn't come see him. And I wasn't aware of it because he had asked the babysitter if he could come see him. And he just didn't come.
And was that one time, and was that just was that Earl, or was it Earl and Charlotte? What was the situation?
He was gonna come see Earl.
And is that the only other time that he had requested time with the kids?
Yes.
Okay. If you would, let me know what's the situation with you and the children as far as the emotional bonds between you. Are you able to show love, affection, and other emotional ties?
Oh yeah, like I love my kids and my kids love me. Like
Okay, and how do you know that?
because baby Earl always he always hugs me and tells me he loves me and gives me kisses and he wants to hang out with me all the time. And Charlotte, she's like a little goober. She's always like happy and she always wants to be right with me. And she smiles and laughs at me and wants to talk with me.
Okay. obviously, Charlotte, let me ask you this. Do you have any religious affiliation, and do you go to church and take the children?
I am Christian, but I don't go to church right now.
Okay. And tell me a little bit about anything you do, because I know that he just finished first grade. And what have you done as it relates to education and, go to conferences, go to school, do things at school? What has been your involvement?
I take him to school every day. I go to his conferences. I talk with his teachers. Yeah, like I do everything when it comes to the school. Like I try to be as involved as possible when it comes to school.
Okay. You work with him on homework or
Yes.
extra educational training, things of that nature.
Yes.
Okay. What do you do?
I help him with his homework. I try to help him with his writing and his reading. Like when he comes home with a book that they tell him he's got to read so many chapters a day, I try to help him. I try to help himself with the reading. Like, have him read it to me instead of me reading it to him, so that way it can be more implanted in his mind what he's reading.
Okay. Tell me, since your separation, who's been responsible financially for the kids as far as providing food, clothing, medical care, etc.?
Me, I have.
Okay, tell me what you've done.
I take them to the doctors every time they need checkups or when they're sick. I work. I work full time, so I buy them clothing and food and toys and books. Like I do everything when it comes to financially keeping them stable.
Okay? And where do you work at?
Dollar General.
And how much do you make at Dollar General?
$14 an hour.
Okay. And you say full-time, is that 40 hours?
Yeah, just about.
Well, I need to know if
Yeah,
it is or isn't.
it's like 35 hours a week.
Oh, okay. Since the separation in November, has the defendant contributed or given you any money for the support of the children?
No, he's giving me nothing. In his words, he said it's not court ordered.
Ma'am, at this time, let me ask you, do you have any significant other? Are you engaged? Anything of that nature?
No.
Okay. Do you have any criminal history or anything like that?
No.
Does the defendant have any criminal history?
No.
Okay. Do you have any mental or physical issues?
No.
And how about the defendant?
He does have some mental issues. Like he had tried to commit when we broke up, and he had to go to Fieldstone. And I don't know what's going on with that, because I know that he was supposed to be on medication and seeking counseling, but I don't know if he's been doing that.
Okay. If we could, let's address for a moment Earl as far as school. What types of, other than going to school, is there other things that he does at school as far as any extracurricular activities, any sports, anything like that?
I haven't put him in any sports at all. Not this year. No, he doesn't do anything extracurricular right now.
Okay. Do you have any problem with the defendant exercising parenting time with the children?
No, I don't have any problem with that.
Let me ask, in your relationship with the defendant, was there any instances of domestic violence?
No, nothing physical.
Okay.
It's mostly like verbal.
Okay. Tell me what would happen in those instances.
He was like, he always, like, cause he would always like accuse me of cheating, and he would call me like a whore, thinking I was always out trying to have sex with somebody, especially if I had to work late, like, because I was a manager at one point, and sometimes you have to work doubles, and he would always like, accuse me of coming home and thinking I was cheating.
Okay. Anything else as it relates to that?
No.
Okay. Anything else that you would like me to be aware of, ma'am?
No.
Anything else that you've thought of as a result of my questions?
Sorry, I do have something I just popped in my mind.
Okay.
Like my son told me that him and his father was asking about me and my ex's sex life. That's what my son was telling me. He came up to me and was talking to me about that.
Okay. Anything else, ma'am?
No, that's it.
Okay. Okay, Mr. Roberts, do you have any questions of the plaintiff?
I only have one question, honestly, and that is, did you tell baby Earl that I tried contacting him on his birthday?
As I told him.
You didn't let him call back?
But no, I didn't let him call because you keep on trying to call. You keep trying to like, oh my God. you keep starting a bunch of crap and trying to get in his head about things. Like,
Okay, that was it. That was the only question I wanted to ask.
Okay. Okay. Thank you. Ms. Marsden, any additional witnesses or exhibits?
no. I was breaking up a little
Okay.
bit.
Hey, Mr. Roberts, this is your opportunity to present your case at this point.
Okay,
So,
this is gonna sound a lot different.
okay, hold on. I'm going to have you sworn in if you're going to testify. Do you have any other witnesses first?
No, I do not.
Okay. Just yourself then, right?
Yes, sir.
Okay. We'll have you sworn in, then we'll proceed.
All right. Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
What would you like to tell me, sir?
Okay, so just to give a quick bit of backstory, we broke up in November. Okay, we had just re-signed our lease for our apartment October 31st. My mother had passed away in August. Okay, and after that, we had only had one cell phone because Fawn had cheated on me 2 times before in the past. Okay, I had caught her doing it both times. And so we cut it down to where we had one phone that we shared and everything like that. One Facebook that we shared, just really didn't have any privacy between each other. Went like that for quite a few years. And then I finally decided to, hey, my mom had passed away. Her phone was still working. So my stepfather was like, why don't we give it to Fawn so that way she can have her own phone and everything like that. I agreed. So Fawn gets my mom's phone. In September, we go through the month of October. About halfway through October, I catch her with a big old hickey on her neck. And I said something to her because her and I hadn't been intimate for at least 2 weeks before that. So it most certainly wasn't from me. She said it was from me and just left it at that. Well, it wasn't. Just a couple weeks later, she says that she's leaving me. I ask her, why is she doing that? She said it's because I just don't love you like I used to. So I tell her, I was like, oh, so you were cheating on me then, And she said, yeah, she had been with this guy for about the past month. So she sends my stepfather to come pick up the kids because once my mom passed away, he kind of attached himself to Fawn. She was kind of his emotional rock. Him and my mom, Fawn and my mom were very similar. And, he just really kind of latched onto her as an anchor to hold on to. And so Fawn stayed with him for a little bit. And then, yes, I did have a really bad mental break. I had been wrongly diagnosed as depressed. I was put on wrong prescription. I shouldn't have been on it. Had a really bad mental break, got drunk, tried cutting myself. One of my family members did a wellness check on me, or called in a wellness check. So the police showed up, saw that my arms were all cut up, and took me to the hospital. They told me that we're going to send you to Fieldstone. You can either say you're willing to go, or we can put you in, what is it, unwilling or something like that. And I was like, no, I'm willing to go and everything like that. So while I was in Fieldstone, I find out that I shouldn't have been diagnosed depressed. I'm bipolar, which makes sense. I've got a long family history of that. With anxiety, they put me on whole new medications and stuff like that. And it's been just going great since then, honestly. Like, oh my gosh, it's like day and night. But anyway, okay, so I get out of Fieldstone. And I find out that she's moved in with her boyfriend Nick. 2 or 3 days after she moves in with him, I get a phone call from her saying, he hit me. I'm moving out. I'm leaving him. And so I'm like, okay, whoa, and she comes and sits and talks with me for maybe about an hour or so. And she has a big old black mark on her face. The bruise was there for weeks. And he calls her up. They talk for maybe 20 minutes. And she looks at me and says, me and the kids are going back to his house. And then I didn't see them. I saw Baby Earl maybe once a weekend in November. And then the day before Christmas Eve, I remember this because it was right before Christmas Eve. And I thought it was kind of bogue. She calls me up and says, well, do you just want Baby Earl to live with you? And I said, yeah, absolutely. I want my son to live with me. At the time, I didn't have a job. Fawn was the one making all the money at the time because she had cheated on me when I was working. So I told her, you can be the one to go to work. I'll stay at home and take care of the kids. So when she left with the job, I was destitute. I had nothing, but I knew this might be my only chance to get to spend time with my son. So I said, yes, give me him. So I had full custody of my son from December 23rd until February 1st. Yeah, because that's when I had to move out of my apartment that we had been living in together and move into where I'm staying at right now, which is my really good friend of mine from high school, Will. I'm living in Kalamazoo right now. Okay. So that was January. Like I said, I had Baby Earl from December until the 1st of February. And I can tell you, Fawn took the food stamp card and all that stuff. I would send her text saying, me and your son are so hungry. Can you please just let me get the food stamp card so we can go get some food? And she'd say no. She'd keep it for her and her boyfriend. And this is when we were getting the pandemic EBT. So we're talking $500-600 a month. And she couldn't spare any to help us get some food. So I end up moving in with my roommate, Nick, and Fawn takes Baby Earl back. He didn't want to go. As far as I know, since day one, he has wanted to live with me and always wanted to live with me. When I have him, I feel bad for him because he tries to tell me about the stuff because as far as I knew, Fawn had been living with her boyfriend up until about 2 weeks ago. I never knew that no one ever said that she was living with her mom or anything like that. She's been living with her boyfriend up until that point. And that's one of what my biggest problem was, because my son would tell me, Nick is saying this, this, and this about me. That's why I made the CPS case, because he flat out said, my son told me that her boyfriend was making jokes about Baby Earl having dogs. I thought that was ridiculous, so I called CPS. And then when we called the police, the reason why we called the police is because the weekend before my son, June 16th was when we had mediation. The weekend before June 16th, so it would have been June 11th, June 10th or so, I was supposed to spend the weekend with my son because I work thirds, so I can only see him from Saturday into Sunday because he had to go to school on Monday and I had to work and all that stuff. So I get a phone call saying you need to come in as soon as you can. And when I show up, my daughter, who's only a year old, has marks on her thighs, big red marks. And my stepfather flat out told me, because he's the babysitter. He's the one who I didn't submit the paperwork, but I've got pictures of his calendar that's full of he kept track of all the times he had the kids. And he had them almost every single day from February up until January, or June, up until June. Because that's when Fawn cut off all contact from the family, because we called the cops on her boyfriend, because my son told me that man had been hitting him and my 1-year-old daughter with the belt. And so we called the police. Fawn shows up, but the boyfriend's nowhere to be found. She tells them that even though they've been dating for 6 months, she doesn't even know what his last name is, and she don't know where he is. It got so bad, even one of the officers drilled her about lying to the police and told her, like, you can't play stupid. Ignorance isn't going to save you. And anyway, so that's when I lost all contact with my son after that point. And even then, she was trying to take baby Earl, and he was fighting tooth and nail. He had locked himself in my stepfather's truck so that way he wouldn't leave because he'd rather be with me. And I've sent her texts almost every single day for the past 2 weeks since she's cut off all contact, just so I could talk to my son, so I could see him. And I get nothing. I don't even get responses. I get absolutely nothing. And I miss my kids. I want to see them.
Okay.
And even though, like, right now, I'm currently unable to have the kids with me because this is only a like 1.5 bedroom right now, my stepfather is 100% willing to be temporary guardian and everything like that to take care of them. But I mean, you can't really do that unless you can prove that the mother's unfit, and I can't really say that she's not fit, but yeah, I'm going to be moving into town pretty soon. I've got plans in motion. I've never had my license or anything like that, or a car, and I'm getting my license this weekend, getting a car and getting a house. That's what I've been telling my son since I had to move out, that it was always to get back together with him and that this is going to be temporary. And, right now I'm working at UPS, kind of bad timing with them planning on going on strike in August, but I'll still get paid during then. I had a job at Jimmy John's, but I quit Jimmy John's to put more time into UPS. But when the strike happens, Jimmy John's flat out told me, you're welcome back at any time. We left on very good terms, so I can always make sure to get my income where it needs to be.
Okay. Just for purposes, what is your income, sir?
Right now, it's $200 a week. I can say for certain. It might be going up soon with all the stuff, but for certain, it's $200 a week.
Are you on salary, or why do you not have an hourly?
No, it's hourly. Right now I'm only working 3.5 hours. Well, I was just these past few weeks because I quit Jimmy John's. I'm putting in more and more time in. So right now I'm starting to work closer to 5 to 7 hours a night. So I'm literally 1 week off from my paychecks finally catching up.
Okay, and how much do you make per hour?
Currently $16 an hour.
Okay.
I will say, when my stepfather was taking care of the kids, I did give him a total of $300, $150 in April, and $150 in May for taking care of the kids. And I did that through Cash App, so I do have paperwork of that. There's a trail.
Okay. The plaintiff had testified that from November to the current date, you've never given her any money to financially support the kids. Is that correct?
That is correct. But that's also on the basis that I had my son for 2 months and she didn't give me any money.
How would you, sir, describe your relationship with your children?
Oh, with my son, it's amazing. It's so wonderful. I love that little boy so much. I mean, I try to help him so much with processing his emotions and stuff like that. For a while, when I had him in December, we only had like 4 or 5 movies that we could watch. I had on DVD, and one of them was Inside Out, the kids' movie about all the emotions in the head and stuff like that. And so we'd sit down and watch that movie, and we would use those emotions and stuff like that to help him work through with everything that he's feeling with all this stuff, and he tells me, he's like, Daddy, when I'm not with you, my emotions go away, you know and Charlotte, I love her to death, but she's so little, I don't even know if she recognizes my face anymore.
Anything else, sir, that you would like me to be aware of?
Fawn was diagnosed with depression back in 2021. She took medication for about a month, and she stopped taking it. In her defense, it did give her severe facial tics, and working at Dollar General, it's hard to be behind the counter making faces at people. But she never did anything to try and get that fixed or get on different medication or anything like that.
Okay. Anything else?
No, sir.
Okay. I'll just, ma'am, I'll just call you. I had additional questions for you based upon the defendant's statements. He said that he had Earl with him from approximately December 23rd through February 1st. Is that accurate?
No,
Okay. And what's inaccurate about it?
no, because my daughter was really like, she was in the hospital for a month. It was in like December into January. I can't remember the exact days, but I know it was about 30 days. She was in the hospital. She had RSV and pneumonia. She had a feeding tube, and I fought hard to get her out of the hospital. I even took lessons there to help for me to put the G tube the G tube in. It was a nasal feeding tube, and I had to go there a few times for them to teach me how to put that in, take it out, how to work the pump for it. But they said that we both had to learn how to do it, and I was the only one there to learn how to do it. And I
Okay.
took her home, and
Okay, that doesn't address my question. He said that he had Earl during that period of time. Then you went off on Charlotte. So how does that relate to what times he had Earl?
I asked him to watch Earl because I had to take care of Charlotte because she had that feeding tube. I asked him to help me so that way I could be on one-on-one time with her to help her because I needed to get her better.
Okay,
But it was a short amount of time that he had him.
okay. And what's the short amount of time?
Like, he had him for like a couple weeks.
Okay. Anything else?
No.
Okay. Anything else that you have, sir? Mr. Roberts?
Lost it.
Apparently he's frozen there. Just a second. We'll see when we can get him back.
There, should be back.
Okay, sir, you have to unmute yourself. Okay.
My apologies. My phone had just died for no reason at all. That just gave me a heart attack. Oh my gosh.
Okay. Is there anything else that you had, sir, that you wanted to add?
No, sir.
Okay. Well, that concludes the defendant's proofs. The defendant is resting. At this point, Ms. March, you can make a closing argument if you wish to do so.
No, I don't have a closing argument.
Okay. Sir, you can make a closing argument now if you'd like.
Yeah, you can see clearly, where the problems lie and what the issues are. There's a lot of information that I wish I could share, but I don't have the facts behind it. So I'm not going to bring it all up, but yeah, thank you very much. I know you know what to do.
Okay. Thank you, sir. Well, in these particular matters, court will note that, again, always credibility is a consideration in every case. Oftentimes, the parties will allege that the other party is not truthful or is lying. The court has found that these inconsistencies in testimony do not mean that a person has lied. Conflicting testimonies can occur as a result of a witness's background, their perception, bias, understanding, misunderstanding, or simply a mistake. When inconsistencies occur, the court will attempt to determine if they can be reconciled through other testimony or evidence. There has been some conflicting testimony in this case, but the court doesn't find that to be unusual or outside of what the norm would be in a case. But the court does utilize that to assess credibility in a particular matter. Custody cases are governed by the best interest of the child test as delineated under the Child Custody Act, which is MCL 722.23, and the court will examine each and every one of those factors in a moment. However, the first task in any custody case is to determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable time, the child naturally looks to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the age of the child, the physical environment, and the inclination of the custodian and the child as to the permanency of the relationship shall be considered. If in fact an established custodial environment exists, the legislator has enacted the clear and convincing burden of proof necessary to change that to minimize the prospect of unwarranted or disruptive change of custody and to erect barriers against removal of the children from an established custodial environment, except in the most compelling cases. In this particular matter, the court has heard the testimony. The testimony has shown that the parties did separate back in November. That's when the plaintiff moved out of the home, that she has, in fact, not resided in the home since that time. She has claimed she was spent time with the defendant's stepfather for a few weeks, I think about 3 weeks, and then she moved in with her mother. There's been some reference to the fact that she lived with a boyfriend for a period of time. However, there's been no, again, corroborating testimony about that, just the allegation. In this matter, it does appear that, again, that over this time that the children have looked to the plaintiff for guidance, discipline, necessity of life, and parental comfort, as the defendant has only had the children for a brief period of time. First, it was testified by plaintiff that it was approximately 3 times. And then we find out that sometime in December or January, she claims that it was a couple of weeks that the defendant had Earl when Charlotte was in the hospital and she was having to provide care to Charlotte at home. The defendant claims that it was for approximately approximately a month, might be slightly over that. However, it does appear that, again, the vast majority of time in this matter, that the children have been solely in the care of the plaintiff. So the court will find, based upon the testimony presented in this matter, that the established custodial environment exists in the home of the plaintiff mother. That's important because the court cannot change custody except by establishing by clear and convincing evidence. Clear and convincing evidence is evidence which would produce in the mind of the trier of fact a firm belief or conviction as to the truth of the allegations sought to be established. Evidence so clear, direct, and weighty and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the precise facts in issue. In this matter, the court will now go over the best interest of the child test as provided under the Child Custody Act. The first factor, love, affection, and other emotional ties existing between the parties involved and the child, or children in this case. In this case, the court will note the plaintiff had testified that, again, the children show her love and affection, that they give her hugs, kisses, hang on to her, tell her that they love her, and that Charlotte always wants to be with her. In this case, the defendant has stated that he has an amazing relationship with Earl. And as he said, he tries to help him process various emotions, etc. He said he loves Charlotte, but he does not know if she even recognizes me, is what his comments were. When I weigh that, I weigh it as to both children. It does appear that both of the parties have exhibited love, affection, and have emotional ties with Earl. It does appear in this matter that those ties between the defendant and Charlotte maybe don't exist or are minimal. The court find that factor, as it relates to Charlotte, does weigh in favor of the plaintiff as to equally as to maybe Earl. Next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, continuation in the education, and raising the children of a particular religion or creed. There's been no testimony much about religious upbringing. The defendant did not testify about that at all. The plaintiff testified she's a Christian, but she doesn't go to church, so the court will not give that much weight. The court does note that the plaintiff had testified that she was involved in schooling for education for Earl. As she goes to conferences, she talks to teacher, she does everything, works with him on homework as far as writing, reading books. He reads books to her, etc. This factor is both to the capacity and disposition, which are two different things. The court finds that the parties each have the capacity. It does appear that the plaintiff has exhibited a greater disposition as it relates to the education of the children, or in this case, Earl. So the court will find that factor does weigh in her favor. Next factor is the capacity and disposition of the parties involved to provide food, clothing, medical care, and other remedial care recognized in place of medical care. The testimony of the plaintiff is that she is the one that makes all the doctor's appointments. The defendant did not testify that he does any of that for the children. Court notes as well that the plaintiff testified from the time they separated in November to current that the defendant has not given her any money to provide for material needs of the children, and he has in fact confirmed that as well. The court will find this factor does weigh in favor of the plaintiff mother. Next factor is the length of time the children have lived in a stable, satisfactory environment, the desirability of maintaining continuity. Apparently, based upon the testimony, aside from the allegations made in this case, the children have been with the plaintiff in the home of their grandmother, except with the times stated previously. So it seems like they do have a stable, satisfactory environment. In contrast, the defendant has stated that he is currently residing with a roommate, and then that's going to change literally almost any day or within a week that he will be moving. So again, that factor does favor the plaintiff mother. Next factor is the permanency of the family unit, existing or proposed custodial homes. There's been no testimony about really any change in the family unit. The court will weigh that factor equally as to both parties. There's been no testimony about either party being morally unfit. As a result, the court will not weigh that factor in favor of either party. In this particular matter, the next factor is the mental and physical health of the parties involved. The plaintiff had testified she had no mental health issues, no physical health issues. The defendant had testified that the defendant did in fact have some mental issues in which he was when the parties broke up, ended up going into Fieldstone, taking various medication. He acknowledged that he did go into Fieldstone, that there was some problem with medication. He subsequently, that he was on, which was incorrect, that he had engaged in some physically destructive behavior by cutting himself, that the police took him to the Fieldstone, but he says that he is bipolar with anxiety, and he is on medication for that. He also states that the plaintiff had some depression previously, and she had some medication for a brief time that caused her to have facial tics back in 2021. It does not appear that she is, in fact, doing anything at the current time. The court will weigh this factor in favor of the plaintiff mother. Next factor is the homeschool and community record of the child. There's not been much testimony about very little about school or community record, very little about the home record. So the court will not weigh this factor in favor of either party, as there's been nominal at best any testimony. Next factor is the reasonable preference of the child. The court considers the child to be of sufficient age to express a preference. The court did have an opportunity to speak to Earl, and the court is taking into account his preference in this matter. Next factor is the willingness and ability of each of the parties to facilitate and encourage a close and continued parent-child relationship with the other parent. The court is taking that into consideration. The defendant has testified that the plaintiff basically has kept him from seeing the children, but by the same token, his other testimony is that he has had the children at different times. But that in the last 2 weeks that she's not responded to his request, etc. And the court will not find that, again, this is sufficient testimony in this matter to evaluate this substantially. The court will not weigh this factor in favor of either party. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the children. There's been really no testimony about domestic violence, other than some testimony from the defendant that the plaintiff and her boyfriend had engaged in some domestic violence. There's been no really corroborating testimony other than the allegation in this matter. And so the court is not going to give much weight to this particular factor, although I will give it some weight based upon the testimony of the defendant. Next factor is any other factor court considers to be relevant in this particular matter. There was some various allegations by both parties against the other as to insignificant and uncorroborated testimony, so the court's not giving that much weight. The court would only note the other factor that would be relevant is the testimony of the defendant stated that he is unable to have the children with him at the current time as he does not have sufficient housing, and he's attempting to move, but there's no testimony about where he's going to move, how he's going to move, or what the arrangements will be. So the court will take into consideration the fact that, as he stated, he is not able to have the children with him at the current time, and that factor will weigh in favor of the plaintiff mother. When the court, in fact, weighs all of these factors, the court does not consider them as a baseball box score where we simply add them up at the end. And whoever has the greater numbers would win. The court can give different and greater weight to any particular factors. But in this matter, because the court has found that there's an established custodial environment with the plaintiff mother, the court would have to show, or the defendant would have to show by clear and convincing evidence that the court should change custody of the children. The court does not find in this matter that the evidence which he has presented even comes to the level of preponderance of evidence. As a result, the court will grant to the plaintiff mother the legal and physical custody of the minor children. With that, the court next has to look at parenting time pursuant to MCL 722.27A. In this matter, the court has various factors the court has to look at there. The court has to look at the best interest, as I've just done, but also has to consider the following factors. Any special circumstances or needs of the children. There's not been any expressed in this matter. Next one is whether a child is under 1 and is nursing. Obviously, there's no child in this case under 1, and there's been no testimony about any nursing, so the court cannot consider that. Next factor is the likelihood of abuse or neglect of a child during parenting time. There's been no testimony about any abuse or neglect of the children, so the court will not consider that as well. Next factor is the likelihood of abuse of a parent during the exercise of parenting time. There's been no testimony to that, so the court will not consider that. Next factor is the inconvenience or burdensome impact of travel on the children. There's been no testimony about any burdensome impact of travel, so the court will not weigh that factor. Next factor is whether a parent is reasonably expected to exercise ordered parenting time. The defendant has testified that he wants to have time with his children, but that again hasn't been ordered, so he hasn't been able to get it, but we'll remedy that today. Next factor is whether a parent's frequently failed to exercise parenting time. There's been no testimony about that, so the court will not consider that. The next factor is threatened or actual detention of the child, of which there's been no allegations, so the court will not consider that. Any other factor relevant to the case, the court, again, has heard the testimony as it relates to the best interest factor, so I am taking all of that into consideration. It does appear that, again, the parties have had some difficulty in communication in this matter. The defendant has stated that there were some times that, again, that the plaintiff has not gotten back to him when he is called. I don't think it's raised to the level the court could, and I have considered and thought about whether the court would order that the parties would communicate through a third-party app such as Our Family Wizard or a family app or something of that nature. I won't do that at the current time. That's always open in the future. If there is not a line of communication, I would tell both of the parties, if the parties get in touch with you as it relates to the children, you should communicate to them. Even if it's a matter of saying, hey, I got your text, I'll respond when I can, or got it, I'll get back to you, or something of that nature. If in fact there is not any communication, then what the court is going to do in the future, the court would order that the parties would utilize a communication app and proceed in that manner. I will let you know there is a cost for again communicating in that way, but if the court should order it in the future, I'll let you know. The court does have access to anything that the two of you communicate with. So just as a result, you should be on your best behavior, because if there's derogatory, vulgar, or disparaging statements made in the communication, the court will have access to that, and it could make a difference on what happens as we proceed in this matter. Hopefully that doesn't have to occur. The court does believe, even at the young age of Charlotte in this matter, that it would be best if when the defendant has time with the minor children, that time would be where he'd have them together in his home. And so what the court is going to do is the court is going to order what they call a standard parenting time, which is alternating weekend. And that's alternating weekend from 6:00 p.m. on Friday to 6:00 p.m. on Sunday, that the defendant will be responsible for picking up and dropping off the children back to the plaintiff. The court will start that parenting time. I don't know what, just to clarify, sir, I don't know when you're talking about moving. Are you going to move this weekend, next weekend, what?
It might be a little bit farther in the future.
Okay.
If we do end up doing it to where I get to see the kids, what'll end up happening is I'll go into town and stay with my stepfather, so
Okay.
that way the kids don't have to travel so far.
Okay.
And
Well, that would be good, because the fact that they'd be familiar with him as well, with him providing childcare to the kids, the court would order that parenting time would start this Friday, July 14th, and then each alternating weekend thereafter. The court would also order alternating holiday parenting time, because presumably the plaintiff has had the children for the holidays leading up to this. The court would grant to the defendant Labor Day holiday, and then alternate each holiday thereafter. Court would award and order during the school breaks that that those would be divided equally, meaning Christmas, that would be divided equally. The parties would alternate spring break. The court would grant to the defendant spring break 2024, and then alternate each year thereafter. The court would award to based upon the age of Charlotte, the court has taken that into consideration for summer parenting time, and that she is very young. The court will, for next year, 2024, would give the defendant 2024 and 2025, the court would give him a week each month in June, July, and August, a full week, from Friday 6:00 p.m. to Friday 6:00 p.m. And then in 2026, that it would go to one half of the summer vacation period in alternating weeks. The court would, in fact, order support in this matter. There has not been a support order in place. The court would note that there were multiple orders submitted in this matter to which there were objections by the front of the court, and therefore a custody parenting time support order never got entered in this particular matter. The court would again note that the defendant has testified that he works UPS. Obviously, that may be short-lived, but he also works at Jimmy John's. If he's not working UPS, he makes $16 an hour. Testimony of the plaintiff is that she works at Dollar General. She makes $14 an hour. The court will, neither the parties appear to be working a full schedule. The court will base the support obligation on a 35-hour per week schedule at the current time, with the plaintiff making $14 an hour, the defendant making $16 an hour. And the court will note that, again, the court will take that and make that support obligation effective back to time when the parties were previously in court and there were orders submitted to this effect. I'm going to take it back to March 1, 2023. Unfortunately, that means, sir, you'll end up with an arrearage in support all along. But again, in view of the fact that you have not paid any support, that would not be, again, that would not be inequitable in this particular matter and fair because, again, the obligation on the plaintiff has been that she has been supporting the children solely herself. With that, I'll ask the plaintiff, Ms. March, is there anything else that you believe the court has not addressed or that I need to address before we conclude this hearing?
No.
Okay. Mr. Roberts, is there anything you believe we need to address that I've not addressed?
No, not at
Okay.
all.
Okay, thank you. Well, what the court is going to do, Ms. March, is you are the plaintiff, you are responsible for preparing the orders in this matter. And just so you know, you're going to have to prepare a judgment of custody, parenting time, and support. And you're going to need to prepare a uniform child support order. And you'll have to prepare a judgment information form. Those three forms, I don't know if you're using a service such as MichiganLegalHelp.org. If you are, they'll have all the forms online that you can utilize and be able to, again, prepare the paperwork. You can put in the numbers that I've given you as far as the support, 35 hours, you have $14 an hour, 35 hours, the defendant at $16 per hour with the two children, and that should kick out the proper support amount. And when you get that paperwork done, you need to submit it to the front of the court for their approval. If they object, which oftentimes happens, they have a form that tells you exactly what they're objecting to. You're going to need to then correct it. And at that point, once you have corrected it, they've approved it, then you're going to have to notice that matter up for entry with the court. Okay? Do you have any questions, Ms. March, on preparing those documents?
Can you just tell me what those forms are again that I need to file?
Yep. The first one is a judgment for custody, parenting time, and support. And then a uniform child support order and a judgment information form. And if you go through like MichiganLegalHelp.org, you'll have all the forms right there. And if not, what happens, this proceeding is on YouTube. If you have a question, you can always go back and review that. It's up for 30 days. And we do that so you have time to prepare the order, get it in. If you do not have it submitted within 30 days, the court's going to start, again, contacting you to find out why we don't have that. And if in fact, we had one yesterday where the party just said, well, hey, it's over. I don't care. I'm not going to do it. And so, okay, you understand if you don't do it, then the case gets dismissed and it's like it never happened then at that point. Okay. So you need to follow up with all the orders to complete the case.
Okay.
Anything else?
No.
Anything else, Mr. Roberts?
No, sir.
Okay. Thank you both. And you have a good day. The court will end this proceeding at 9.